Hey everyone, Harry here to talk about Trump's 11th hour effort to try to delay the New York DA Alvin Bragg trial that's set to start in less than 2 weeks, a week from Monday with jury selection. So very belatedly, and that's going to be a problem because motions to dismiss already have past their deadline, and the judge made a point about just this. Trump parachutes in with a really lousy argument to delay the whole trial, and it is based on immunity, his favorite topic for now, while it's pending in the Supreme Court. So the argument is this immunity appeal case is pending in the Supreme Court. They're going to hear the case April 25th. You should put this case, Judge Merchan, the judge overseeing this, remember, Stormy Daniels, really election interference case, this effort to keep the truth of the affair from coming out and damaging his electoral chances in the wake of the Access Hollywood tape, says I'm immune, and you need to wait until the Supreme Court has decided the case. And I'm not only immune, goes the argument, but that means that you can't, the DA can't even introduce as evidence anything I did while president. How totally crappy is this motion? Let me count the ways, but then go on to the possible unhelpful punchline. All right, it is the fact that the Supreme Court is somewhere considering a case that might have some effect on some development of law somewhere is not a reason to not go forward with a trial. That sort of thing happens and the system can account for it if and when the Supreme Court issues a ruling that changes the law. But until then, it doesn't mean much. That's, I would say, well, all right. So let's go an increasing level of crappiness. Around there also is he has waived this claim a couple times. He's waived it here by not having brought it, and he waived it by trying to remove the case and arguing immunity at the time, or tantamount to the same, by saying he was, couldn't be, had to be in federal court because of official acts. That would be a really strong reason in a lot of cases. But I think here, given it's Trump and the prominence of it, most judges, and maybe Merchan will be one of them, would be wary of using waiver, even though Merchan immediately said, why are we doing this 2.5 weeks before trial when the deadlines have long since passed? So that's waiver. Then immunity itself. First, there's probably not going to be and shouldn't be immunity for criminal conduct, and if it's different in state court, that would be a whole issue that the Supreme Court isn't considering, and so there's no reason to delay it there. He can bring that up in state court. Moreover, even if there were immunity, and I'm sort of working my way up the ladder to more and more conclusive reasons, even if there were immunity, none of his conduct here would be covered by it. The most it could possibly be is what it is in the civil context, meaning outer perimeter. And the conduct is largely the real crime and fraud scheme and required the alteration of documents and the like happens during the campaign when he's not president. And there's just a few things that are sort of follow through thereafter. And then finally, his real claim here is to keep evidence out of the trial because he says it constitutes official action as president. First of all, and there's two glaring flaws. One, none of it constitutes official action as president. He's talking about, he says so expressly in the papers, the supposed pressure campaign on Michael Cohen to, cover things up, et cetera. Does that sound like the act of an official act of a president? But then most sound, there's just zero holding, zero law, and zero reason that an act, being official or not official, but undertaken by a president, means you can't introduce it as evidence. That's a crazy notion. I'm thinking right now just of the Iran-Contra cases and the introduction of what Reagan did and had to say and the like. It's relevant evidence. Immunity couldn't possibly mean that a jury couldn't hear this evidence. So it is really lousy 6 ways from Sunday, or I probably should say Monday. Monday, that is March 25th. However, what happens now? Because first of all, Merchant, the judge, was peeved at the dilatory raising of this so soon before trial, but he's shown every intention to make very quick work of it. He's given the DA until tomorrow, 48 hours to respond. So he will probably very quickly rule on the motion, and I would say deny it. Now, under New York law, the question will be, can Trump try to take a trip up and down the New York courts, at least to the appellate division first, the intermediate court, and then the Court of Appeals, which is the name of the highest court in New York. New York's really confusing because trial level courts are the Supreme Court, and this one, the highest, is Court of Appeals. But can he go up that way? In general, New York courts are indulgent to interlocutory appeals. And so you can't discount the possibility. I've looked into it. I don't think there's a proposition of law that flat out precludes it. Possibly if Merchant and the appellate division together say this is so crappy, we won't even hear it. But the question is, can he at least get a very quick hearing in the appellate division? It's not as easy in the highest court, which is more discretionary. But if he does, I think, we already have seen the appellate division be aware of his delaying ways. So I think still the likely outcome is that Merchant very quickly this week rules against his motion. And if he's able to get to the appellate division, they also make quick work of it. So in other words, even if, and this is the sort of asterisk I referenced up front, does it give him a shot at delay? Maybe a little one if he can take a trip to the appellate division and up and down, but I don't think a long one. In other words, what he wants to have happen is wait till the Supreme Court rules. And of course, that wouldn't even do it. After they ruled, then there would be a whole question to litigate. It would take months of what's the meaning of their ruling in this federal court case to state court, and let's decide, et cetera. That's what he's looking for. And we would very quickly be in the fall and, imperiled even on this one case. I think rather, if there's a delay, it'll be a short one and it won't materially. We'll still be getting this trial, maybe still even March 25th, though can't discount the possibility of a short delay. That's my take on it. You can imagine, the highest court in New York, or you can imagine his getting cut a big break, finding another judge, Eileen Cannon, out there. But I don't think so. And certainly starting with Merchant, who's onto him, I don't see much indulgence there for what is a meritless, waived, and very late motion. Talk to you later. Hi, everyone. Harry here with a really exciting announcement. Talking Feds is bringing our lively discussions with prominent national figures live to San Diego. Talking San Diego is a new series of conversations with some of the country's most interesting and bright minds from the worlds of politics, public policy, law, and more. Our first event is just around the corner. Join me for a conversation with Congressman Jamie Raskin on Monday, March 18th at 2 o'clock in downtown San Diego. You can click the description box below for more information on the event and the series and find out how to purchase tickets, which are going fast. I can't wait to have some of our most well-known friends of the podcast join me in person before a live audience. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.